Disappointed in the Supreme Court gun decision. There is one little bit of solace.
The president calling on Congress to pass red flag and safe storage laws and strengthen background checks.
He pointed out a Supreme Court ruling back in 2008 that said that the Second Amendment is not absolute.
After Charleston, after Orlando, after Las Vegas, after Parkland, nothing has been done.
Gun laws in 40 of these states are still in place based on the decision. Not good enough.
To go to school, to a grocery store, to a church, without being shot and killed. While this bill doesn't do everything I want, it does include actions I've long called for that are going to save lives.
Biden challenges Fifth Circuit. All right, so picture this. The Biden administration is like, hold up, Fifth Circuit, we've got some beef with your ruling on ghost guns, and guess what? They're taking it all the way to the Supreme Court. So what are these ghost guns that everyone's talking about? Well, they're not some spooky apparitions haunting your closet. Nope, they're actually DIY firearms, kind of like those build-your-own model kits, but way more serious. These kits contain all the parts you need to put together a fully functional firearm, and here's the kicker. You can do it all without having to register the gun. That's right, no paperwork, no background checks, nada. Now why is the Biden administration all fired up about this? Well, it all comes down to the Gun Control Act of 1968. This piece of legislation defines a firearm as any weapon that can expel a projectile using explosive action. But here's where it gets tricky. The act doesn't specifically define what constitutes a frame or receiver of a firearm, and that's where the Fifth Circuit stepped in. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, or the ATF, tried to tighten the reins on these ghost guns by expanding the definitions in the Gun Control Act. They wanted to include these DIY kits under the umbrella of what's considered a firearm, but the Fifth Circuit wasn't having it. They said, hold on there, ATF, you're overstepping your authority. According to them, unless Congress explicitly says otherwise, the ATF can't just go changing the rules. But the Biden administration is like, nah, we're not backing down. They're arguing that the ATF's changes are totally in line with the spirit of the Gun Control Act. They're saying, hey, if it walks like a duck and quacks like a duck, it's probably a duck. In other words, if these DIY kits can easily be turned into functional firearms, then they should fall under the same regulations as traditional guns. And that's why this whole showdown is heading to the highest court in the land. The Biden administration wants to make sure that when it comes to ghost guns, there are no loopholes that let people skirt around the law. It's a battle for tighter gun control measures, and the outcome could have a big impact on how we regulate firearms in the future.
While a firearm so equipped would still be regulated by the Gun Control Act.
Disappointed in the Supreme Court gun decision. There is one little bit of solace.
This rule redefined firearms with stabilizing braces as short-barreled rifles.
The president calling on Congress to pass red flag and safe storage laws and strengthen background checks.
The ATF's final order. Alright, so let's dive into the nitty-gritty of the ATF's final order and what it means for gun control. So the ATF, aka the Bureau of Alcohol, Tobacco, Firearms, and Explosives, they're like the referees of the gun world, making sure everything stays within the lines of the law. In April of 2022, they dropped a bombshell known as the Final Order. This was their attempt to crack down on ghost guns, those sneaky DIY firearms that fly under the radar. The Final Order was all about expanding the definitions laid out in the Gun Control Act of 1968, aka the GCA. They wanted to make sure that these ghost gun kits didn't slip through the cracks of regulation. The idea was simple. If it walks like a duck and quacks like a duck, it's probably a duck. In other words, if these kits can easily be turned into functioning firearms, they should be treated the same as regular guns. But then enter the Fifth Circuit. They took one look at the Final Order and said, hold up ATF, you're going too far. According to them, the ATF was overstepping its bounds. You see, the GCA doesn't explicitly define what counts as a frame or receiver of a firearm, and since the GCA is like the rule book of gun regulation, the Fifth Circuit said the ATF couldn't just start making up new rules. But here's where it gets interesting. The Biden administration isn't backing down without a fight. They're arguing that the ATF's changes are actually spot on with the spirit of the GCA. They're saying, hey, we're just trying to close loopholes and keep people safe. They believe that by redefining what constitutes a firearm, they can better regulate these DIY kits and prevent them from falling into the wrong hands. So where does that leave us? Well, it's a classic showdown between federal agencies and the courts, with gun control hanging in the balance. Will the ADF's final order stand, or will the Fifth Circuit's ruling put a damper on their plans? Only time will tell, but one thing's for sure: this ain't the last we'll hear of the battle over ghost guns.
He pointed out a Supreme Court ruling back in 2008 that said that the Second Amendment is not absolute.
When attached to a firearm, does not convert that weapon to be fired from the shoulder.
Gun laws in 40 of these states are still in place based on the decision. Not good enough.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
Supreme Court appeal. Alright, so let's break down the Supreme Court appeal and what it means for how we define firearms. First of all, the Biden administration isn't backing down from their fight against the Fifth Circuit's decision. They're bringing their A game to the Supreme Court, arguing that the ADF's final rule is totally in line with the Gun Control Act of 1968. Their main beef with the Fifth Circuit? They say the court got it all wrong when it ruled that the ADF overstepped its authority. According to the administration, the final rule's provisions are actually spot on with what the GCA intended. But what exactly are these provisions, and how do they stack up against the GCA? Well, the final rule aimed to expand the definitions of firearm and frame or receiver to include those pesky ghost gun kits. The idea was to make sure these kits couldn't fly under the radar and avoid regulation. And according to the Biden administration, this is exactly what the GCA had in mind when it was written. They're saying, hey, we're just trying to keep up with the times and close loopholes in the law. But here's where things get tricky: the legal debate over the interpretation of firearm definitions. You see, the GCA doesn't explicitly define what counts as a frame or receiver, and that's where the Fifth Circuit drew the line, saying the ADF can't just start making up new rules. But the Biden administration argues that the GCA's provisions are broad enough to encompass these DIY kits. They're saying, we're not trying to rewrite the law, we're just interpreting it in a way that makes sense for today's world.
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
President Biden went on to point out that states have their own ability to make state-by-state gun legislation.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
Broader implications. Let's zoom out and take a look at the bigger picture when it comes to gun control efforts and how the Supreme Court appeal fits into the puzzle. First off, this appeal isn't just about ghost guns and DIY firearm kits. It's part of a larger push for tighter gun control measures in the United States. With gun violence on the rise and mass shootings becoming all too common, there's a growing sense of urgency to address the issue. But it's not just about preventing tragedies, it's also about closing loopholes and keeping firearms out of the wrong hands. Take, for example, the ban on firearms for individuals under domestic violence restraining orders. This is another challenge making its way through the courts, and it's a crucial piece of the puzzle when it comes to gun control policy. You see, domestic violence is a leading cause of gun-related demises in the United States. Every year, thousands of people are slain by intimate partners with firearms. That's why laws preventing individuals with restraining orders from owning guns are so important. They're designed to protect survivors and prevent further violence. But here's the thing: these laws are only effective if they're enforced, and that's where the Supreme Court comes in. Their decision in cases like the one involving domestic violence restraining orders could have far-reaching implications for gun control policy nationwide. Will they uphold these laws and prioritize public safety, or will they strike them down, potentially putting lives at risk?
While this bill doesn't do everything I want, it does include actions I've long called for that are going to save lives.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
To go to school, to a grocery store, to a church, without being shot and killed.
your right to own a gun can also be restricted.
Garland versus Cargill. let's unpack the case of Garland versus Cargill and what it means for the contentious debate surrounding bump stocks and auto weapons. First off, Garland versus Cargill is a major legal showdown that's set to decide the fate of bump stocks. Now, what exactly are bump stocks? Well, think of them as aftermarket accessories that can be attached to semi-auto firearms like rifles. What do? Well, they essentially enable the gun to fire rapidly, almost like a fully auto weapon. How? By using the gun's own recoil to repeatedly engage the trigger, allowing for a continuous stream of fire with minimal effort from the shooter. Now here's where things get interesting: the legal argument. You see, the heart of the matter revolves around how we define a mash gun. Federal law defines a mash gun as any weapon that shoots or is designed to shoot automatically more than one shot with a single function of the trigger. So the question becomes, do bump stocks fall under this definition? Well, it depends on who you ask. Some argue that because bump stocks enable rapid fire with a single push of the trigger, they essentially turn semi-auto weapons into mash guns. Others, however, contend that bump stocks don't technically make the gun fire automatically, as the shooter still has to maintain continuous pressure on the trigger. But here's the kicker: the Supreme Court's decision in Garland versus Cargill could have far-reaching implications for the broader legal landscape. You see, there's this thing called the Chevron precedent, which basically says that courts should defer to federal agencies' interpretations of ambiguous laws. However, recent indications suggest that the court may be leaning towards overturning Chevron, and if that happens, it could shift the balance of power, giving the court more authority to interpret laws as they see fit.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
After Charleston, after Orlando, after Las Vegas, after Parkland, nothing has been done
to end some of the restrictions, which some people call restrictions, I call safeguards.
You would think the head of the agency tasked with regulating the entire firearms industry.
That's gonna do it for this video, you guys. See you next time, and bye for now.